or making your opening and closings, please just stay close to the lectern. Don't wander about the well too much as you're doing your questioning. You're welcome to use your own laptop at trial to run your trial presentation software. Like I said, just ensure that your exhibits in your software corresponds to the numbers on the clerk of a court's exhibit list. And if you would like to test your equipment ahead of time, you're welcome to do so and come into the courtroom to do a trial run. Just contact my division and they'll be happy to set up a time for you to come and test your computer and software in the courtroom. The court has an Elmo, an easel, and a connection for your laptop to use in the courtroom. Are there any other special equipment needs that you anticipate, Mr. Connolly?
No, Your Honor.
Mr. Cause?
No, Your Honor.
Trial memoranda, I don't require those, but if you feel like it would be appropriate on a complex issue or another legal issue, you're free to file one if you'd like. The fact that we won't be having a jury really sped that up. So outside of discussing the motions in limine, is there anything that I haven't covered that you have questions about, or anything I need to clarify, Mr. Connolly?
I don't believe so. I believe opposing counsel stipulated to our largest damages component, but we can nail that down between ourselves. But I don't think anything else.
Okay. Mr. Cause?
I would agree as well. We will need at some point, and I don't think briefing's completed till August 5th. There's a motion to amend that is pending to add counterclaim that I'm sure the court probably hasn't reviewed yet since it's not been fully briefed. If the court would like a little insight into the motion and what it is, I'll be happy to provide it. But it has to do with repairs and reparation to the subject wall under the CCRs. An approval by the HOA to do the repairs. The defendant requested access to the wall to fix it, was denied by plaintiff, thereby raising the claim based on the denial under the CCRs, which we believe requires reasonable accommodation to allow that repair. In any event, the motion, our reply, I believe, is due, and that's what I was looking at real quick, August 5th, I believe, August 3rd, it looks like. So we'll probably try to file that a little bit. I'd like to get it filed by the end of this week, but as soon as possible. But that is another issue that'll need to be addressed.
Okay.
Otherwise, I'm not seeing anything, and I think counsel and I can put something together on that damage issue that he mentioned.
Okay. I haven't reviewed it yet because it's not fully briefed. So I'll probably just wait until I get the reply in and then address it at that time.
Yeah, and since it's a bench trial and we're not polling a jury, the timing's a little less concerning. So
all right. Then I'll address that when the reply comes in. Outside of that, anything else before we move on to the motions in limine, Mr. Cause?
no, Your Honor.
Okay.
I don't know.
All right. So let's start with plaintiff's number one. Mr. Connolly, do you have any oral argument you'd like to present on it?
Sure, Your Honor. I'm not sure how robustly relevant it is anymore since we might be having a bench trial, and I'm sure your honors reviewed the documents, but just on the issue of liability, there was a concern that was conveyed via some emails that perhaps defendants will try to split hairs or argue that there might be liability for negligence, but not for contract or vice versa. And we just want to make sure that we don't get bogged down in such arguments during the trial.
Okay. Mr. Cos?
Yeah, I think it's moot at this point. And I think it would not have been for a jury to begin with. That's an issue. I believe that's just purely a legal issue.